willing to work if they don't have any other income, that may flag, but you can certainly have them pay the dues at this point if you have for not actually following its rules and procedures. Yes.
I have a question about mitigation.
Yes.
So ignoring false statements or lies on the part of the advisor, as a consumer, to what extent do I have a responsibility to ask reasonable questions in situations such as this? So just trying to flip it around a little bit.
Yeah.
So if you're defending that advisor, to what extent is that part of the equation?
Yeah, so certainly there is some mitigation, some contributory negligence arguments. I mean, if you sit here and I put assuming I've actually, the advisor actually given all the documents and the client signed off, if you say, look, I'm not a high-risk investor and I don't want to be in these high-risk investments, but I signed off on them, and for 3 years I'm rolling in the dough while these investments came forward, and then all of a sudden they crash, can I turn around and say, well, wait a minute, you didn't put me in these things? So to a certain degree you can say you acquiesce to those things and you consented to those issues. But in terms of a duty to mitigate, it is really going to be dependent on your relationship with that particular client. If they are sophisticated, they have some knowledge, there's going to be a bigger requirement that they actually take some responsibility. But if we get to a situation where they are entirely dependent on you, and an argument can be advanced that you actually exist in a fiduciary relationship with them, such that you can actually unilaterally impact their decisions, and then there isn't even a duty to mitigate. They can actually say, well, yes, we saw the investments going down, but we don't have to mitigate. It's a fiduciary obligation you're on for our entire losses. So it will be depending on the nature of the relationship and the advisor. Yes?
Why was, during the course examination, why was the omission, what the advisor made, would that be relevant to as the prime motive of the advisor? More than anything is to make the big omission? Why was?
Yes. So again, every time there's a lawsuit, it doesn't necessarily. There may not be an investigation from the FDA. So like I said, so what you would have to do is, if your client's going to sue you, say, look, I'm suing you for my investment losses because you put me in investments that were inappropriate. In order to go through that, I would have to. There's a much bigger trail you have to establish. So I would have to, like I said, I have to say, okay, tell me about your investment knowledge. Okay, have you invested before? What did you know at school? You get this information, and you would make a decision. I'm going to put you as, no investment knowledge, and I'm going to put your risk tolerances here. You would have to demonstrate why you selected those issues. Well, you identified your client as being, someone who's interested in moderate high-risk investments. Why is that? That's a judgment call. All right, there's defenses available there saying, well, look, I had all this information. I've spoken to them. In my judgment, we talked about it. I think, given their, they were only in their 30s, they had a long term ahead of them, they knew they wanted to do things. Based on everything, I was able to assign this risk category. That's how you would normally have to build that foundation. Here, because of an MFA, the cross-examination is tailored differently. She didn't need to ask why. We know, because of the hearing, we know that I put them down in moderate risk investments when that wasn't their risk tolerance. So she didn't have to establish a foundation. She simply had to get to admit, listen, the MFA agreement says this. Do you agree with that? Yes. So you agree with me, you put them down here. Yes, and that was a mistake, and you knew that. Yes. So she didn't have to lay that foundation because she'd already had this document. That's how it gets used. But in the absence of this sort of document, this sort of hearing, you'd have to lay that foundation in a different manner. So her emphasis on here was using that. In fact, you can take it, that hearing, the results and the revisions there, that's very much how we would use an examination for discovery of trial. If ever I tried to, well, that was just a mistake, I don't remember. Well, you seem to make a lot of mistakes. Let me show you another mistake that you made over here when you admitted it. You see, you admitted it 25 times. Same sort of way we'd use the transcript for an examination discovery. At trial, you start to weasel out and say, well, I'm sure I would have discussed. Well, actually, you already told me you didn't discuss and you had no notes. Isn't that true? So this is really almost how a trial will work, and a cross-examination of a trial will work, using your examination for discovery evidence.
Failing the MFDA exertions, would you not rely more on the signature of the client? Like 25 clients agreed they were medium to high risk when they weren't? That's ridiculous.
Well, that's assuming that when the loan documents went up to the advisor, he had placed them there. I don't believe the advisor actually signed off on being moderate. So he had their statements, and what he put on the loan documents was different. I'm not sure the clients always signed off on those. And that's why these admissions or just related generally as opposed to one individual client.
But
But yes, that would be
the KYC would be signed.
Yes, yeah,
The loan application would be signed.
it should be, yes.
The payment agreement would be signed by the client.
Right, and there's gonna be some of that mitigation argument in there, but when we've admitted that I made a mistake and that the suggestion is not a mistake, it's that you deliberately did this and that's the way it's going. But those are arguments that you would advance to undermine, absolutely.
Right, yeah, I just don't see how somebody could do that 25 times and get away with it from their
Compliance
MGA.
yeah. Yes.
What was the outcome of that?
Yeah, I don't know if the trial was over, because it was forced down a trial, I suspect it might end up happening with settle, because we don't have a.
So it's still on trial?
Well, they tried to do the summary judgment saying they didn't need to go to trial, and then because it forced back to trial, and I didn't, to be honest, I didn't look it up, I believe that it settled before trial. I mean, he made the admission, he was told he was gonna go to trial, so I believe that there was a settlement, but we can find out, absolutely.
How often do they end up in the settlement?
How much do they,
No, how often does it end up in a settlement?
Oh.
As opposed to trial?
80%.
I think generally speaking, 98 to 99% of matters settle before trial. Some of them get right to the steps of trial, but 1 to 2% of all matters go through the litigation. So it's very rare. I mean, you go to you go through the examination discovery process, you go to mediation, and that's very few that go to trial. I mean, there's a lot. I'm not saying there's not a lot of cases, but when we every so often we do a top 10 case of the year. If we say that there's 30 trials a year, yeah, I think that's just a small percentage of issues that had come. I mean, all the people in 2008 in the Great Recession went through their lawsuits when they lost investments. We'd still be dealing with all those cases today. So a lot of them settle after discovery and mediation. And once the lawyer looks at, like, we look at something like this, we'd say, look, we're going to lose a trial. Let's see if we can settle that. They obviously went to a summary judgment motion, and now not that they would have gone to trial. About 1 to 2% actually go to trial.
From your law practice, is it wrong to do leverage with seniors? And a second part, could I be sued as a rep because I did not present to my client a leverage opportunity that would help them to meet needs in their retirement?
Okay, well,
You can't hear.
okay, so the question was twofold. It was, can you be sued for not recommending a leverage settlement? And is it inappropriate to recommend leverage settlements to seniors who may not be working? So I'm not going to give you a definitive answer to that latter question because I don't want you to take that advice and go in there and it goes bad and I'm now on that seat over there. No, it depends. I mean, when you're looking at those things, when you're determining to make a leverage settlement, the court's going to look at a variety of factors and say, okay, it's a leverage settlement. Because there are higher risks with that leverage settlement, are your clients able to deal with the downside? So if they're not working, but they've been very, very well off and they've got other investments that provide them with some sort of fixed income so that they know that if at the end of the day this goes sour, they're going to be doing it. If your entire portfolio is a leverage settlement, they're going to say no. I think that the courts are going to look at if you're retired and you're not working, a minimum of 20-25% of any portfolio investment should be in sort of fixed income or some much more safe investments. So there isn't a definitive answer. Just because your client is a senior is not working, that doesn't include them from being a good candidate for leverage mortgage, but you got to make sure that they've got those capabilities to access other funds and they won't be financially crippled if this one investment goes over. In terms of being sued for not recommending a leverage settlement, no. I mean, you look at your investment, we've made a determination, I just don't think this leverage settlement is for. If you want to put it to them and say, I don't believe, this has come across my desk, I don't think it's for you, I've recommended, I don't believe there's going to be a cause of action. You didn't recommend a risky settlement to me, and had I gone into that risky settlement, I would have been a millionaire now. I don't believe that's a cause of action. What you'll end up having is, if you recommend an investment, that something else would have been more suitable. Those initiatives. If you're recommending your client and you make a judgment call based on one or the other, provided you can show that that judgment call made sense, you're not going to be found liable for failing to recommend a leveraged investment. Now, if you tell them that you don't believe it's for them, it's not something you recommend, but they want you to put in, they want you to do it, and you still don't because you say, well, I don't think they know what they're doing, then you can be in trouble in that situation.
the takeaway in the room that if anybody has leveraged or clients in leveraged investments, they should be probably running back to their office, reviewing who those people are, and maybe sitting back down with them and reassessing risk tolerances since
Yeah,
we're
it is a
9
good-
years
because-
into a frothy market and visiting volatility, right?
Yeah, it's a good example. I mean, if you've gone back, certainly if you've taken some notes. I mean, it's always good to review your clients' files on when you update your KYCs, you've got an obligation to update them regularly. Financial situations change, so I agree. Just waiting, things have been going 9 years. I just do a perfunctory thing, but absolutely, if you've got leveraged settlements, it doesn't hurt to go in to make sure that things aren't going south, or that you've at least you can trust yourself and say, well, I got the notes, I indicated what's going on. It's hard to retroactively fix yourself, but it doesn't hurt to always look at your clients to make sure that they're still on pace to doing what you.
That would probably be a more favorable outcome for the advisor if he documented the fact, revisited this, suggested it wasn't appropriate, take some profits.
Exactly.
Client still didn't want to do that.
Yes, and as long as you voted up, absolutely, for sure.
Isn't the takeaway really, if it's not in writing, it didn't happen?
Yes, so if it's not in writing, it didn't happen. Now, I agree that we can argue no, provided if you come across as a credible witness and you can do it. I won't say that the lack of documents is ultimately fatal, but it's a massive hurdle to overcome, right? Especially when if it's really I said and my client said and there's no documents. Now I don't have exact notes, but my client I get the plaintiff say, yeah, I remember him saying yes, there were some bad sides, but I agree. If it doesn't, it's a good rule to live by. You should put notes on all key decisions. Absolutely. Yes.
If you have an older couple that one of them has dementia now, and they transfer out to do a leveraged loan, what should you do as an advisor? Should you get involved or just let them go? We had that happen.
I mean, it's going to depend on the relationship. I mean, do you have discretionary authority over these accounts? I mean, if you know that your client's got dementia and is, I'd be very hesitant about taking instructions from that person if you believe that's going to be the case. But if you suspect it, and boy, I think you've got to take a positive step and say, look, I'm concerned about this, because you don't want to be faced with, well, I didn't know what was going on. My client was, I would have a field day with that if I was on the other side to find out you put a client into leverage settlement that went south when you knew or had suspicions that your client was.
You let them transfer out.
Back here.
What's the responsibility of the branch manager, the compliance officer, and were they dragged into this case?
So the response, that's going to depend a certain degree on the relationship that the branch has got. Certainly, if the advisor's an employee, there's going to be vicarious liability. I don't know. Each branch office and the branch manager may have independent acts. Maybe if the advisors don't have the authority to recommend or put a client into leverage settlement, absent the branch signing off, the branch is going to have its own liable for its own independent act there.
If you have, if you had a E&O situation where somebody filed a complaint with your E&O division and they paid off against your decision, would that be held against you?
Well, paid off the settlement. Presumably they're going to make a payoff in exchange for the release. So if there's a release, they paid off, then they'd be included for bringing civil action against you. But I've had cases where there's been a complaint to the organization. The organization said, well, we're not paying it, we haven't done it wrong.